In fact, in 43 of the 48 air zones within the UK, they failed to comply with the emission levels set in the directive. I'm actually sure none of you would be all that surprised to hear that today, 2016, 18 of the 28 members of the European Union are not in compliance with this directive. So the case was heard before the European Court of Justice in July 2014, and judgment came out in November of 2014. And the court ruled on the matters presented by the UK court completely in Klein Earth's favor. The plan should have aimed at compliance by no later than 2015, and the UK court was not only permitted to, but must order the government to comply. The national courts must be able to provide a national remedy for the violation of the EU law. And as I mentioned, this is now applicable for not just environmental law, but for all EU directives. The national courts have to provide remedies for breaches of European law in the nation's courts. The case was then returned to the United Kingdom Supreme Court for implementation of that decision. And we had another argument before the UK Supreme Court in April of 2015. The judgment came out, and the court basically, again,
well, this is the broad structure of the talk, but as I mentioned, I'm going to fly over some of these slides. Just a few facts and figures on Delhi. Delhi is, as you know, regarded as amongst the most grubbiest cities in the world. And it has a population of 18.6 million. That makes it second to only Tokyo. But apart from the very large number of people, it's also got a very large number of vehicles. And the vehicle population is 8.8 million. There was a growth in vehicles a decadal growth between 2005 and 2015 to the extent of 294% insofar as four-wheelers are concerned. And there's an increase in industrial production as well, which, as you can imagine, results in air pollution. The World Health Report, and this really shook up the judiciary in India because they initially waited a while for some sort of an executive and parliamentary response, but when none was forthcoming, as I will explain to you, the judiciary really stepped in. But the WHO report for ambient air quality in 2014 found Delhi to be the most polluted city in the world. Second, and this is unusual for a court, they imposed what was effectively a tax called the Environment Compensation Charge per vehicle. So if you wanted to come into Delhi, despite this prohibition, then you have to pay an environment compensation charge. So you can imagine that's, from at least a lawyer's standpoint, quite a difficult sort of thing for a court to do. Where is your competence, where is your capacity to impose a charge such as this?
For the enforcement of judgments and orders, because the presentation of Ms. Rose, I think, showed quite clearly how difficult implementation and enforcement of really good judgments and orders, how difficult it is. And I was wondering what experience you might share of the use of contempt laws in enforcing orders, because it struck me that enforcing that order of the Supreme Court of the UK was essentially contempt of that order, that the UK government hasn't complied with the clean air requirements. That was simply my question. Thank you very much.
Of divergence between me and our UK lawyers, because as an American we use contempt all the time in this context. I have been advised by my UK colleagues that in the history of the Supreme Court they have only a government ministry, a department of the Secretary of State, has only been held in contempt twice. And they were actually cases where it appeared that the government ministers wanted to be held in contempt. It was a kind of a protest. So we've been advised by our in-house and external solicitors that it is virtually impossible to get a contempt order. So we've had to be a little bit more creative in the way we frame our remedy request, framing it in terms of just getting more specific procedural direction from the court as to what the Secretary of State has to do.
So we used it. Now this is given under the Constitution, under our powers to look into fundamental human rights, the violation of HR action, human rights action in the Supreme Court using Article 126. which also gave us powers to make directives. So this was under a directive, under human rights application that had been filed in the court, a fundamental rights application that had filed in the court. Now, because it came under fundamental rights application, it was an order given by the Supreme Court, who had exclusive jurisdiction to give that order. Now, a violation of it down the line, far away in a tiny little village, Supreme Court is an overall jurisdiction, territorial jurisdiction. Well, it was a violation of the order because it interfered with the GSMD officials' right, mandated by the Supreme Court, to walk in there and do the report. He was physically, he broke his leg. So we dealt and said, you brought him into court. And he said, we are going to deal with this on the fundamental rights, on violation of contempt of court.
Australia having the pollution as well, like Bangladesh also. But Divan says they have the tribunal. And we believe that India is taking very good measure nowadays. But fortunately or unfortunately, Bangladesh, we have a lot of public interest litigation regarding environment. Once we do the case, the Supreme Court give rule and stay, Supreme Court give direction, and once it is violated, we file contempt, Supreme Court show causes, but in most of the cases, is the public representative, member of parliaments, and the ministers, those who are violating that. Nothing happens, police never goes there, and in a stage, head of the state had to say, either Supreme Court is running the country or we are running the country. If we are running the country, Supreme Court keep little bit silent or rather poking their nose on all these issues.
You've got the common law. Bangladesh is a common law country. So as was said, as our friend from Sri Lanka is, think about public nuisance cases. There may even be, if you're talking about, and I'll leave now Shyam Devan to talk about this, is that what about a trial smelter type approach? If there is pollution coming from India into Bangladesh or Bangladesh into India, the recipient country could take some action. So thinking outside the square there may be some actions under international tribunals which you can take action. If, for example, if there's a World Heritage Area.
And I wonder, I respect the Indian lawyer, as a whole, India, very old country. But I wonder if the judges, the Supreme Court justice, have capability to consider all factors of the environmental, to make the factors to make environmental policy.
Enforcing its orders, it's very, very effective. Let me assure you, the moment the ban came in, there was no registration of any vehicle of over 2000 cc in the entire Delhi region. The original order was for 1,400 square kilometers. Thereafter, they expanded it to 49,000 square kilometers, which is probably 2/3 the size of Sri Lanka. But I won't get into those details. The point, I think the tension which you mentioned is very palpable in the Supreme Court, because there's even in this common law system and a constitutional system, there are several commercial, economic, political interests who feel this is not the legitimate role of judges.